On this week's episode of the podcast, the Protecting Tenants at Foreclosure Act.
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner with Yesner Law, and as always, the podcast is brought to you by both my law firm, Yesner Law, and also the book, Crushing Debt. And I'm still running that special offer, and I've been sending out books. And so anybody who wants a free book, all you need to do is leave the law firm an honest review on social media, either Google or Facebook or whatever social media platform. Take some kind of screenshot, take a picture, let me know in some way that you've left that review for the law firm. Send it to me along with your address, and I'll autograph a copy of the Crushing Debt book, and I'll send it to you. One other way that you can get your hands on the book is by going to Amazon and type in Crushing Debt or type in Sean Yesner, and you'll get a copy of the book. You'll be able to order, you'll be able to buy a copy of the book that way. But as you heard in the introduction, I wanted to tell you about a law called the Protecting Tenants at Foreclosure Act. Now, I don't know that that's proper grammar. Should be Protecting Tenants in Foreclosure Act, but it is literally called the Protecting Tenants at Foreclosure Act. Now, this is a law that I've talked about before, or at least blogged about before, because it is a law that existed from 2009. And it expired in 2014. And so I'll get to why I'm talking about it now, so many years after 2014, especially based on when you might be listening to this episode. But basically what the Protecting Tenants in Foreclosure Act or at Foreclosure Act did was it was designed to help tenants, renters, who were in a house that was being foreclosed. A lot of times the landlord wouldn't tell them that the house is in foreclosure, and out of the blue suddenly they get all these foreclosure notices, eviction notices, whatever. And so Congress stepped in and created this Protecting Tenants Act. And what the act does is it says that if the bank acquires the property in a foreclosure sale, they have to give the tenant who's in the house 90 days notice or through the end of the lease term, whichever is longer. And so I'm recording this in March. And so let's say that the tenants had a lease through the end of October and they got foreclosed and the bank came in and bought the house. Well, the bank would either have to honor the lease for 90 days, so April, May, and June, or they'd have to honor it through the end of the lease, October, which is ever is longer. In this case, the bank would have to honor that lease through October. And so the bank would then start taking rent payments from the tenant. Now, there were a couple of qualifications. I mean, the tenant had to be in the house at the time the foreclosure was filed. This couldn't be something where the tenant could sneak into the house the day before the foreclosure sale and the bank would have to honor that lease. The tenant would have to be in there. And there were different applications of the law depending on whether this was bought by the bank or bought by an investor, or whether it was a written lease or whether it was a month-to-month lease. I believe if it was a month-to-month lease, the bank only had to give 90 days regardless of the length, because by definition, a month-to-month lease is month-to-month. So if it were a month-to-month situation, the bank had to give a minimum of 90 days notice before they could get rid of the tenants. Now, if this was a third party that bought the property, if it wasn't the bank, if it was somebody that bought the property at the foreclosure sale, then they would also either have to give 90 days notice or through the end of the term of the lease, whichever is greater, whichever is the longer period of time, unless the investor wanted to live in the house as their homestead. If that was the case, I believe they only had to give 30 days notice to get the tenants out. If they intended and desired and actually lived in the house, the third-party buyer, the third-party investor, if they lived in the house as their primary residence, then regardless of the length of the lease, I think it was 90 days notice that they had to give, and then they could move into the house. I don't think Congress wanted to interfere with the rights of somebody buying property to live in the house. So that was the Protecting Tenants in Foreclosure Act. Now, unfortunately, like I said, that law sunsetted, that law expired in 2014, at the end of 2014. Now, when that happened, Florida law kicked in for those of us in Florida. For those of you listening in other states, I'm sure your state may have a similar law. The Protecting Tenants at Foreclosure Act is a federal law. And so when that federal law expired, the different states had their own laws. And so here in Florida, the law that kicked in said the buyer at the foreclosure sale only had to give the tenant 30 days notice. That's it. After 30 days, they could begin their eviction proceeding. So it was only 30 days notice. Florida was a little bit more strict than the federal government. And so at the end of 2014, Florida's law kicked in, which said 30 days. If you're outside the state of Florida, I would recommend that you go ahead and research the laws in your state to figure out what your state says in terms of the landlord-tenant law. But that's the way that the law worked in 2014 when it ended. Now, I'm happy to report, so a couple of weeks ago actually, I was at a note buyer seminar. And it was with our friend Scott Carson. He's been on the show. He has the Note Closers show, and he also has the related podcast. And I met up with Scott here in Tampa to do a note meetup group and talk all about buying and selling and the legalities and all that stuff. That was a couple weeks ago here. At that meeting, one of the attorneys that I know that was at that meeting that actually represents lenders regularly in foreclosure cases gave me a little hint, a little tip that the Protecting Tenants in Foreclosure Act may have come back. And so I did a little research, and I found, in fact, she's right. The Protecting Tenants in Foreclosure Act did come back on May 24 of 2018, as a matter of fact. So I apologize that it's been a little bit more than 6 months. I try to stay current, and I try to keep you all current on the different changes in the law. And I guess we're less than a year, so we can say that this one is still relatively current. But on May 22nd, it passed the House, and on May 24, it was signed by President Trump. The Protecting Tenants at Foreclosure Act became a permanent law. So at least as I understand, it has no sunset date. It has no end date. It is now good forever. And so we're now back to the stage that if the bank buys the house at the foreclosure sale, they have to give 90 days notice or go through the end of the lease, whichever is the greater period of time, whichever is the longer period of time, they have to honor that. And so I think that's a really good law now here for tenants who are in foreclosure, people that are being taken advantage of by people who are in foreclosure who want to rent out their property. Now, again, I've done podcast episodes on this topic before as well, and I don't think it's really a problem if somebody wants to rent out a house that's in foreclosure. I know I've litigated the issue a handful of times, and typically what the judges have said, what the way the judges have come down, at least here in the Tampa Bay area, is that these are two separate contracts. And so the contract that the landlord has with the tenant is one contract, and the contract that the landlord has with the bank, the note and the mortgage, is a totally separate contract. And if the owner of the house, if the borrower under that mortgage, if the landlord, all three of these people being the same person, want to rent out a house while it is in foreclosure, that's okay. I think where they get into trouble is that they don't tell this to the tenant up front. And I think the reason they don't tell it to the tenant up front is because then the tenant will want to negotiate a lower rent, or the tenant will not take the unit because the tenant fears, and a lot of people have a fear that the bank is going to come in and throw them out. And it doesn't necessarily happen that quickly. I mean, of course, if you rent the house on the eve of the completion of this process and you rent the house on the eve of an eviction, then yeah, I mean, you may wake up one day and there'll be a note on the door that the sheriff is going to come and throw you out. But in most cases, this is something that is a longer process, and so the tenants will get plenty of notice that there may be an issue here with the house. But still, I understand how it could be a legitimate fear, and I've talked before about how to get rid of that fear. One of the best ways to get rid of that fear that I may be kicked out at any moment, you want to write it into your lease agreement. You want to tell the landlord that it is a material component of you renting this house, that it is not currently in foreclosure and it will not be in foreclosure in the future. In other words, as long as you make your rent payments, the landlord will submit those rent payments to the bank to keep the house out of foreclosure. Now, sometimes what the landlords will do is, for example, if they have your rent as $900, but their mortgage payment is $1,000, then instead of cash flowing that property, they're actually out of pocket $100 a month. And in situations like that, the landlord may not have enough money. If you take that a couple more zeros, or you make it a $500 negative or a $600 negative, the landlord may eventually get to a point where they can't afford to keep up the mortgage payments out of their pocket, and they'll let it go into foreclosure. So those are the questions you want to be asking as a tenant when you're moving into property is, what is this? What's the situation? What's the financial situation? Obviously, the landlord's not going to give you his financial situation, but you at least want to ask questions and be prepared to know that this is not a mortgage foreclosure situation, to know that the rent payments that you're making are being used by the landlord to pay the mortgage payment. If they're not, then you may have a way to get out of that lease without penalty, but it's got to be written into the lease, and it's got to be a material factor in your decision to rent that unit. If those two things are missing, then what I've seen under Florida case law is the judges saying that those things are two separate contracts. The lease being one contract, the note and mortgage being a different contract. And just because the landlord happens to be behind on the note and mortgage has no impact. It does not entitle the tenant to stop making payments under the lease agreement. Now, again, I want to temper all of this. This is Florida law, and this is Florida law here in Tampa. There may be other areas in Florida where the judges take a different stance. There may be other areas of the country where the judges take a different stance. So if you're a tenant and you're listening to this podcast episode, you really want to check with an attorney in your area if you get any foreclosure notices to make sure that there's no issues, to make sure that you can stay in your home for a little bit longer. Now, before I finish the episode, I did want to take a minute and tell you all about a new podcast app that I discovered. So the name of the podcast app is Podcoin, and it's an app that pays you to listen to my show and every show, and it's a podcast player that will actually pay you. You can get the Podcoin app on iPhone or Android. It's free and it's super easy to use. You can use the Podcoin app to claim gifts based on points that you earn, or you can donate any of those points that you earn to charity. It's amazing. It blew my mind. I downloaded the app. I started listening to shows on the app. I started to get points appearing in my account that I can use either to buy myself some stuff or to donate to charity. It's a great app. I really enjoy using it. I've only been using it here for a couple of days now, but it is really, really good stuff. So I do use the app to listen to a lot of the podcasts I listen to now. I really enjoy the app. I would really appreciate it if you would go to the App Store or wherever the Android store is and download the Podcoin app. You can use my invite code, which is Yesner, Yesner, and Podcoin will give you 300 Podcoins just for signing up if you use my code Yesner, Yesner. I would really appreciate it if you go to the Podcoin app and give it a try. But to finish out this week's episode of the Crushing Debt podcast, I wanted to again remind you the Protecting Tenants at Foreclosure Act is now back. It is now permanent. So if you're a landlord and you are in foreclosure and you're wondering, can I rent this house out to a prospective tenant? I would definitely say yes, you can. But I would also caution you to disclose up front that the house is in foreclosure, and at some point, they may be asked to leave by the bank. But at the same time, you can tell them about the Protecting Tenants at Foreclosure Act. Now, don't try to describe it to them. Don't try to give them legal advice. If you want, you can refer them to me, and I will give them the legal advice about what it is, and I'll do it in such a way that doesn't make you as a landlord look like such a bad guy. So you can tell your tenants that there is a federal law that protects them in the event that the house is foreclosed. But that's only if the house is in foreclosure or the payments are falling behind. One other way that you can sort of soften that blow, like I said, you can reduce payments. So, I mean, let's face it, if you're a landlord and your house is in foreclosure and you've got it rented out to a tenant, you're really not using that money to try to catch up the bank. So why not give the tenant a little bit of a break to make it more enticing for the tenant to move in? and use the facilities and pay you rent. You could give the tenants other things. You could give them different price breaks. You can give them the ability to sublease. You can do a lot of things that are perfectly proper, perfectly legal, things that a landlord may not do, but because the house is in foreclosure, you want to make sure that you take care of your tenants. If you're a tenant, then I would put down in writing and make the landlord sign and attest to the fact that the house is not now in foreclosure, that he is right now current on payments, that he has no intention to fall behind in payments, that he will use your rent to make the payments on the mortgage, that the amount of your rent is sufficient to cover the amount of the mortgage payments. And so you want to go through and put all these things in writing, and you want to make sure that your landlord is representing these things to you so that you have a comfort level that the house is not going to be in foreclosure and that you're not going to be kicked out one day because the landlord has stopped making his payments. One other interesting thing I noticed about the Protecting Tenants in Foreclosure Act is that tenants with Section 8 housing vouchers do have additional protections that allow them to retain their Section 8 lease and require the new party that takes over the property to assume the housing payment assistance contract that's associated with that lease. And so that was another protection written in for tenants by Congress, approved by the president when the Protecting Tenants in Foreclosure Act was renewed here back in 2018. So I think that, most of the landlord-tenant issues that I encounter are over one of two things. Number one, they're over money. So the tenant did some damage, or something happened, or the tenants haven't paid, or the landlord isn't making a repair. The other issues that I see in terms of landlord-tenant law is just that, the landlord's not making repairs. Interestingly, I had a friend of mine contact me today with an issue. They're a landlord, and they signed up a lease with a mother and father, and the parents put their son in the unit. Now, the son was not on the lease, and this is an adult son and adult parents. The son was not on the lease. The parents were. Well, the cops came in and busted in the door and raided the apartment, and it turns out that the son was some type of drug dealer. I don't know what kind, whatever kind of drug it was. And so they busted in the door. They messed up the unit pretty bad. They got the son, they put him in handcuffs, and they dragged him off. And so my friend's question was, well, how do we prevent this guy from coming back into the house? How do we protect the other people in the community? What do we do here? Well, again, under landlord-tenant law in Florida, everything's going to be covered by the lease. Sorry, I tried to combine those two words. Governed or covered by the lease agreement. And so what does your lease say? Do you have a clause in the lease? Most leases should have a clause that say any illegal activity is a breach of the lease agreement. The fact that the parents who were on the lease had the son who was not on the lease living in the unit was a breach of the lease agreement. There's something called quiet enjoyment. In other words, you can't allow your use of the property to interfere with someone else's use of the property. Again, another breach of the lease agreement. So the advice I gave to the landlords, to the owners was, hey, listen, send the unit owners a letter. You are in breach of your lease agreement because XYZ. The police raided and took your son away. You're not living there. Your son is living there. Your son was conducting illegal activities in connection with the unit. Your son is making it dangerous for other residents and interfering with their quiet enjoyment. And again, spell it all out. If the parents don't do something about it, you can then terminate the lease and evict them. So that was what I suggested to them. You could also look at getting an injunction. That's not something that I regularly do in my practice, but maybe an injunction to prevent the son from moving back in. Maybe that would be appropriate if the situation were dire enough. That's maybe something you could do. But I think, here in Florida, the typical eviction does go fairly quickly. From the time of service, there's 5 days to respond. The defendant then has to serve his answer. The defendant also has to pay money into the court registry. If the defendant does not pay money into the court registry, they are not entitled to maintain any defenses unless that defense is, I made all my payments. But in a situation like this where the unit was raided and that was the type of breach either the tenant would have to deposit rent into the registry of the court to maintain any defenses, or this would be the type of situation that there are no defenses available, and so the tenant just would have no defenses at all. And so I think step number one is you work it out with the tenant. You call the parents, you say, look, here's what happened with your son. I hope he's okay. What's going on? Or maybe you don't say, I hope he's okay if he's slinging drugs. Maybe no one cares. But, I hope everything's okay. What's going on with your son? By the way, why is your son living there if you're the one on the lease? By the way, why is your son doing drugs out of my house? How do we fix this? How do we resolve this? If the parents don't do anything to get their son under control, like immediately, and if the parents don't do anything to show some remedy of this situation, we start the eviction proceeding and we get them all out. We don't care if the parents signed the lease, if they didn't sign the lease, if the son signed the lease, if he didn't sign the lease. We don't care. You're all out. And so that's the way that I think I would handle it. Now, there's two parts to an eviction proceeding. There's part number one that says we want you out of our house. That goes on a fairly quick timeline. Then there's part two that says we want money damages from you. That's a little bit more difficult because you've got to really take a look at who your tenant is. If you try to evict somebody that has no money, they have no job, they've stopped paying rent because they lost their job, or they have some kind of medical illness or divorce or any one of these issues that causes them to lose money and not make any money, well, then suing them for money really is just an exercise in futility. But if you happen to have somebody that has money, then yeah, go for it for the damages that they've caused to your unit. And so that's, I think, all that I really have for you this week on the Crushing Debt podcast. If you guys are in a landlord-tenant situation, please let me know. Sean at yesnerlaw.com, SHAWN at YESNER law.com. You can also interact with us. We're on social media. Both the firm, Yesner Law, and myself individually are both on Facebook. I do have an Instagram account, which is Sean Yesner. If you go onto Instagram, you can find me on Sean Yesner and all the posts that I put there. And so I would really appreciate you all interacting with me. Tell me your landlord stories. Tell me your horrible tenant stories. Tell me your horrible landlord stories. Maybe we'll do another podcast episode with some funny stories about some landlord-tenant interactions. But I think that is it for this week's episode of the Crushing Debt podcast, and we look forward to talking to you in next week's episode.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.